My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. You know, when we talk about educating and informing the public, really there are all sorts of levels of information. There are all sorts of levels of education that we provide in the context of this video series. Today I want to talk about something that's really very, very basic, but I think it's important to know that where your starting points are in the divorce process, and that's why we're doing something so basic right now. How does the divorce process begin? Where should one start their divorce process? Okay, so you have to understand one thing. When you start a divorce, you're talking about filing this in the circuit court. You're not filing this in the lower district court like in small claims. This is not something that's going into the federal court that has no jurisdiction. You're filing it in the county court, in the circuit court. Now, circuit court where? I mean, you live in Oakland County, he's been living in Macomb. Where do we file? Well, the answer is, if you've got a situation where you've been living in the county for at least 10 days, and you've been living in the state of Michigan for more than 6 months, and maybe you're separated, so he likewise has been in the state of Michigan, but in a different county, the answer is you can file where you reside. You can file where he resides. The county that has jurisdiction is the one where either parties live in for at least 10 days. So there may be a reason to file in one county more than another. Maybe one county is a very busy county and the ability to get before a judge is diminished. The other county happens to have a smaller population, less of a docket. You can get before a judge quicker. You may prefer that or not, depending on what your situation is. So you'd have to figure that out, and your lawyer can give you advice on that and may tell you, you know what, all things being equal, I'd rather file in Macomb than in Oakland. I'd rather be in Wayne than Washington. Who knows? Whatever the choice, you get your lawyer's input on that so that your lawyer will tell you where we begin our process. And then, how do we begin the process? Well, the process begins by the filing of a summons and complaint for divorce. Sometimes the complaint is called complaint, sometimes some jurisdictions call it a petition. Either way, it's an initiation of a process whereby you're telling the court, I was married, I live in the state of Michigan for a certain amount of time, I live in such and such county for at least 10 days, therefore I'm allowed to come before the court and ask for help. The help that I'm asking for is a divorce. I'm asking the court to help me dissolve my marriage in a fair, equitable way, taking into account all the issues. Custody, parenting time, child support, property division, asset allocation, debt, you know, all these things. So when you file it in the county, that's essentially what you're asking for. And so your lawyer will put together a complaint or petition for divorce and along with it a summons. And those will be filed with the court clerk in the county of whatever particular county you chose. Now, assuming that you have jurisdiction in that county, it's going to be assigned from the county clerk to a judge on a random basis within that county. So, for example, in certain counties, like in Oakland County, you got a whole bunch of circuit court civil judges who might take a divorce case. It's going to be given randomly to one of those people. They, in turn, will issue a summons. The summons is essentially an order to take action. The summons says, I'm attaching this to the complaint, sending it back to the lawyer so that it will be served on the other side, so that the other side know they have to do something. They have to take some action. They have to file an answer within a certain amount of time. By the way, when I say we have to serve it on the other side, what I mean is we've got a complaint that we filed, stamped with the court stamp. We've got a summons signed by the court clerk with dates by which it has to be served. And we've got to get those papers to the other side somehow. There's all sorts of methods by which to accomplish this somehow. It could be that you'll call the other side and they'll come to the law office and just pick them up and sign, I got them. That's an easy way, right? Another way would be you could send them to the house, certified mail. They sign the little card and then the post office sends it back to the firm and we know that you've been served. It could be like that. It could be sending a bailiff or court functionary to the home and handing it to the other side saying you've been served. I'm sure heard about that. What you may not know is of all the methods of service, and there are many legitimate methods of service, one method that isn't legitimate is husband can't serve a wife, wife can't serve the husband. The parties cannot serve each other. Parties cannot serve each other because the court is concerned that someone may say, I served them, and hide it under the couch. And then the other side doesn't respond, and then they're defaulted. The court wants to avoid that. The court generally wants service done by someone who's got no horse in the race. no stake in the game, doesn't care if you're served or not, so therefore won't deliberately try to not serve you. But here's my point. As we start this process, there are a bunch of different ways to serve. There's a bunch of different strategies that go along with how we file, where we file. Now that we got this judge, how do we do this, how do we do that? And you know who's best to help you navigate that? A lawyer with experience in this kind of field, in this area. If you have any questions about your particular case, of course, reach out, and our experienced lawyer will be glad to help you out.